An introduction to Alternative Dispute Resolution, or ADR for short. ADR is a form of alternative dispute resolution without engaging the legal system of any given state or territory. Arbitration is the most well-known and common form of ADR, although there are other forms of ADR. In recent years, ADR has gained in popularity. The factors which have seen an increase in the use of ADR include: number 1, the low cost, and number 2, the speed of resolution. I've set out below the different forms of ADR which are commonly used. Arbitration. Arbitration is a procedure where a binding decision is made on a dispute between a person appointed by the parties to the dispute. The person appointed by the parties is referred to as an arbitrator. Arbitration normally arises from a contractual relationship between the parties, where arbitration might be agreed within the contract agreed between the parties. In standard form contracts, arbitration might be provided under the jurisdiction clause. A jurisdiction clause will set out which court or tribunal has jurisdiction over the contract. An agreement to refer the dispute to arbitration will often be found here in the jurisdiction clause. The standard contractual provision has changed in recent years from arbitration to ADR. This allows the parties to choose the different forms of ADR which are now available. Conciliation. Conciliation is a procedure of settling disputes in a friendly manner. Conciliation brings opposite sides together to reach a compromise in an attempt to avoid taking a case to a formal legal process. Conciliation may even be engaged before or in conjunction with arbitration. Conciliation is best used in employment-type disputes or in family or divorce proceedings. The conciliator acts as a neutral third party. The conciliator need not have any legal qualifications. Mediation. Mediation is a procedure for settling disputes. Mediation can be initiated at any stage of the dispute resolution process. Her Majesty's Courts and Tribunal Service, HMCTS, provide a free mediation service after the commencement of legal proceedings in the County Court. Similarly, mediation can be terminated at any time. It is important to remember that no decision can be imposed by the mediator. The role of the mediator is to assist the parties in reaching an agreement. However, a mediator can provide a non-binding assessment of the dispute. So, mediation is similar but not the same as conciliation. Mediation is suitable across financial, business and family disputes. Adjudication. Adjudication is the process of dispute resolution where the adjudicator appointed makes a decision on the dispute. Adjudicator will review the evidence of the arguments and determine the rights and obligations of the parties in accordance with the relevant applicable law. It is important to remember that the decision of the adjudicator need not be binding upon the parties. The parties themselves will decide before reference to adjudication whether the decision of the adjudicator shall be binding upon them. An example of a typical adjudication is the Ombudsman Service. The government or a trade association may provide an ombudsman scheme for its members, who then make adjudication available to their users or customers. The rules of the ombuds scheme differ, but it is common to find decisions only binding in the event that the consumer or customer decides to accept the decision of the adjudicator. Examples of ombudsman schemes include the Private Lands Appeals, or otherwise known as POPLA service, on behalf of the British Parking Association. POPLA is an independent appeals body provided by landowners who provide car parking, land or area. Decisions by POPLA are not binding on the consumer unless the consumer chooses to accept the decision of the adjudicator. By contrast, the rules of the London Arbitration Centre provide that the decisions of the adjudicator is final and binding. The purpose of the Ombudsman scheme is to provide a redress for consumers without having to engage legal proceedings.